Yes.
My lords, my lady, can we move on then, please? 3 years in the line of authorities now to customs and others, please. The judgment starts in volume 2 of your authorities, tab 35, at page 444. But we can pick it up at 450, please.
450.
Yes,
Yep.
please, 450. In this case, the European...
What was it about? Just to...
Yes, I was just about to...
Oh, okay. Thank you. Yeah.
In this case, the European Court is considering a case where the Irish authorities have relied on the Halifax abuse principle to deny an input tax claim, but there wasn't any national legislation in Ireland that permitted that. So that's the facts.
Yeah.
Page 450 then, please, paragraph 30. The court iterates the principle that abusive practices are prohibited is applied to the rights and advantages provided for by EU law, irrespective of whether those rights and advantages have their basis in the treaties. Various authorities cited there, and at the bottom of paragraph 30, it's thus apparent that the principle is not of the same nature as the rights and advantages to which it applies. So when the court is thinking of my learned friend's examples, his 4 scenarios, one knows that the principle is not the same as the rights. So that's not the correct approach in our submission. Paragraph 31. Going slightly further in our submission to say that the principle as applied to the sphere of VAT displays the general comprehensive character which is naturally inherent in general principles of EU law. 32, according to the court's case law, refusal of a right or an advantage on account of abusive or fraudulent acts is simply the consequence of the finding that, in the event of fraud or abuse of rights, the objective conditions required in order to obtain the advantages which are not in fact met. So one doesn't need a specific legal basis. And that's why in paragraph 33, the principle that abusive practices are prohibited may be relied on against a taxable person to refuse him inter alia the right to exemption from VAT. So it goes over the page of paragraph 34. It's clear from that we submit that the case law extends to both cases of fraud and situations involving abusive practices. We go over the page to 452, please. Paragraph 43, bottom. Court's dealing with the question there of whether the appellants could invoke the principle of legal certainty. And the court says it's settled case law that the taxable person who's created the conditions for obtaining a right in a fraudulent or abusive manner is not justified in relying on those principles in order to oppose the refusal to grant the right in question. So we rely on Cousins for the following propositions. Firstly, the anti-fraud and anti-abuse principle displays the general comprehensive character, which is naturally inherent in general principles of EU law. Paragraph 31. Applies to all rights or advantages under the VAT system. Paragraphs 30, 32 and 33. It applies to both fraud by the taxpayer and abusive practices. That's paragraph 32. And if a taxpayer has created the conditions for obtaining a right in a fraudulent or abusive manner, can't rely on legal certainty to defeat the abuse principle. That's paragraph 43. Both Shern import and Cousins were then considered by this court in different constitution. In the case of Butt in 2019, judgment is of Lady Justice Rose, as she then was, with which my lords, Lord Justice Gross and Peter Jackson agreed. The facts, before we turn to it, my lord, my lady, it concerned a penalty for VAT fraud under sections 60 to 61 of VATA, based on the company's involvement in the fraud transaction. I can ask you to go to volume 1, tab 26, page 153, please. Paragraph 24 at the bottom. J, which deals with the effect of customs. The bottom there, drawing a distinction between directives that don't have horizontal direct effect and the effect of settled case law. So the principle that abusive practices are prohibited is applied to the sphere of VAT by the case law stemming from the judgment in Halifax, displays the general comprehensive character which is naturally inherent in general principles of EU law. So you can rely on it to refuse exemption even in the absence of provisions. And then if one goes over to page 158, please. Paragraph 39 at J, please. The abuse of right principle is, according to customs, naturally inherent in general principles of the EU law. It's a freestanding principle that applies irrespective of the ability of the national provisions to be subject to conforming interpretation. This is addressing the point that EU law has moved away from how it characterises the abuse principle into something now completely inherent and freestanding within it. And then over at 42, next page please, G, the effect of the CJ's rulings is that, as the court said in Halifax, notwithstanding formal application of the conditions laid down by the relevant provisions of the 6th Directive and the national legislation transposing it, the objective criteria for deduction are not in fact satisfied because the right to deduct has been exercised towards you. So in our submission, the Court of Appeal in but confirmed the scope of the anti-fraud and abuse principle and how it works. And so, in summary, on the general anti-fraud and anti-abuse principle, we submit that the effect of the CJ EU authorities can be distilled as follows. Firstly, EU law cannot be relied on for abusive or fraudulent ends. Secondly, the principle is a freestanding one, naturally inherent in general principles of EU law. Thirdly, it applies to the VAT system since preventing possible tax evasion, avoidance and abuse is an objective recognised and encouraged by the PVD. Fourthly, the principle applies to cases of both fraud and abuse. Fifthly, it applies to all rights, benefits or advantages under the VAT system in the same way. 6, it operates as follows, and simply that when fraud or abuse is present, the objective criteria for the relevant right, benefit or advantage are not in fact met. 7, a taxable person who knew or should have known that he was taking part in a transaction connected with the fraudulent evasion of VAT is, for the purposes of the PVD, regarded as someone whose conduct is fraudulent, because they aid the perpetrator of the fraud, become their accomplice, such an interpretation by making it makes it more difficult to carry out fraudulent transactions and therefore is apt to prevent. Number 8, the principle in general applies as much to someone with a cartel state of knowledge as it does to someone who's directly a VAT fraudster or who directly carries out an abusive transaction. 9, someone caught by the principle can't invoke legal certainty or fiscal neutrality to escape its consequences. 10, the application of the principle does not create a penalty. And 11, any other interpretation would not comply with the objective of preventing tax evasion, as recognised and encouraged by the Directive.
Sorry, can you just repeat that last one?
My lady, any other interpretation would not comply with the objective of preventing tax evasion, as recognised and encouraged by the Directive. And so we submit that the Upper Tribunal's conclusion at paragraph 72, that the abuse of law principle in the VAT context is broad and extends to those who facilitate VAT fraud, was correct. As we've submitted at paragraph 18 of Skeleton, in the deregistration context, as the Upper Tribunal recognised at paragraphs 84 to 85, limiting the effect of the anti-fraud and abuse principle to those who are themselves directly fraudsters, as opposed to those who knew or should have known of the fraud of another, would run contrary to the CJU's approach, both in cartel and in shirring. And in our submission, there is no good reason why the approach and rationale in those cases should not also apply to registration under the same system. As the Upper Tribunal said, paragraphs 85 to 86, any other interpretation would not comply with the objective of preventing tax evasion, avoidance and abuse. And the interpretation that it did adopt was apt to prevent fraudulent transactions, because deregistration addresses the future risk of abuse of the system. And we do submit, as we did at paragraph 19 of the skeleton, that it would be a remarkable result if applying the principle to the VAT system permitted refusal of input tax and zero rating to those who aren't directly fraudsters but are treated as such. It doesn't permit their VAT registrations to be removed by reintroducing the very distinction between fraudster and facilitator that the CJU erased in cartel. The two rights stem from the same system. The anti-fraud and abuse principle is freestanding and applies equally to all the rights and advantages stemming from it. That is the point we derive from Sherman. And there is, in the light of that judgment, therefore we submit no principled basis for the distinction between a right, advantage or benefit in terms of VAT registration and other rights stemming from the system. We submit that the principle operates in the same way for VAT registration. You might continue to meet or initially meet the objective conditions for it, but if you're intending to use it for fraud or to facilitate fraud of another, for abusive purposes, then the objective conditions are not in fact met. And as we submitted at paragraph 20, restricting the general principle in this context to those who are themselves fraudulently evading VAT would seriously restrict that general, comprehensive and freestanding principle with no rational basis for doing so. It would mean, if the appellant is right, that even those with a stated intention of engaging solely in abusive transactions, or solely in transactions that they know are connected with the fraud of another, would have to be permitted VAT registration. we do submit that standing back, that cannot be the correct outcome of the application of an anti-fraud and anti-abuse principle. As we submitted in our prefatory observations, orchestrated VAT fraud schemes do not simply involve the default. CJU recognised as much and could tell. The appellant's approach instead is apt to produce that charter for those who knowingly facilitate VAT fraud. So we do submit the Upper Tribunal was correct to conclude as such at paragraphs 86 to 87 when it found that the appellant's approach would not be consistent with CJU authorities or the broad scope of the principle, that it would run wholly contrary to the aim stated in the PVD of preventing fraud and abuse of the system, and it would provide a charter for those who facilitate that. Paragraph 21 of the skeleton, we submit that the same logic applies to this untainted supplies notion. Again, it is apt to create a charter for fraud because, as my learned friend is reluctant to concede, even the possibility of a single untainted supply on the appellant's case means you can't be deregistered. So even if you are the defaulting trader, you buy a printer to print your invoices, you bought it from Curry's or some high street name, you say, well, that's not connected with the fraudulent evasion of VAT. Curry's have accounted for the VAT on that. You can't deregister me. That is the practical effect we submit of the appellant's case. As the Upper Tribunal recognised, paragraph 58, any proper restriction on deregistration based on untainted transactions, we submit, is not a question of principle, but a question of fact and degree in any given case. And that deals with the proportionality of doing so, as opposed to the principle line in the sand my learned friend seeks to draw. So I set the principle, the genesis of it, and it's in that context that we invite the court to look at Oblessio, where it fits and what it does. And in our submission, the better approach is to ascertain whether there's anything in that judgment that sets out the types of limits contended for by the appellant, bearing in mind the principles emerging from the authorities as summarised. And we submit that there is not. One has to read the judgment as a whole to determine it. And as one notes, that the court proceeded in Oblessio without even an Advocate General's opinion. It's not taken as laying down any new point of principle, less still we submit, trying to restrict the broad scope of the anti-fraud and anti-abuse principle. Can we turn to the judgment then, please? It's in your second volume of the authorities, tab 33. Pick it up at page 381, please. 381, paragraph 15. 15 sets out the actual questions that were before the court. And one can see, we submit immediately, that what the CJEU went on to say went well beyond the scope of the questions that were being asked. What it ended up saying about refusing registration was not the obvious subject of any particular argument before it, still less an argument that the principle could only be applied to fraudsters or those making solely tainted supplies, still less that it couldn't be applied to chains of transactions such as Incatel. And each party, of course, lights on various points of the judgment as meaning this or perhaps meaning that, but one has to read it, we submit, best in the actual context of the fraud and abuse principle and of what was before the court. There are general statements. If one goes over to page 383, please. Paragraph 28. mantra now in these cases, perhaps unsurprisingly, that prevention of tax evasion, avoidance and abuse is an objective recognised and encouraged by the directive. But it's a broad statement, as I understand my Lord Justice Popplewell picked up during the learned friend submissions. It's not just confined to fraud, for example. So the general principle is stated as being broad. Paragraph 30 is the reference to misuse of identification numbers, and then an example given. Not we submit the CJU saying you must be a fraudster for this to qualify, for this to apply to you. And misuse, we submit, is plainly of wider import. And it is relevant in our submission that the court didn't refer to misuse by the taxpayer, but misuse in general. Paragraph 34 is the essence of, bless the old, probable. The VAT identification number assigned to that taxable person will be used fraudulently. We submit the Upper Tribunal is correct at paragraph 74 to refuse to draw the inference that this must be limited to fraudulent use by the taxpayer refused registration. As the Upper Tribunal said, the court didn't say by that person. And in any event, if that's what the court was actually saying, one has to go back to Kittle, which confirms that if you have the state of Kittle knowledge, you're treated as fraudulent by the system itself. The judgment doesn't begin to rule out that kind of established principle in our submission. The learned friend relies on paragraph 36 over the page at 384. Taxable person's fraudulent intentions. Again, Kittle doesn't rule out what that actually means in this kind of context.
Sorry, when you say Kittle doesn't rule out, you're saying Kittle tells you to read fraud in a broader sense.
It doesn't tell you, and I accept there's no explicit signpost, but it doesn't tell you not to. If the fundamental principle of Kittle is you're treated under the PVD as a fraudster if you participate in these transactions and you know or should have known, one has to somehow read that out of this judgment if the appellant is correct. The Upper Tribunal at paragraph 75 said of this paragraph that the focus here is on the factors that might be relevant in the overall assessment of the risk of evasion, not the scope of the principle itself, and we submit that that's correct. Paragraph 38, you've seen, my lord, my lady, the reference to might result in the misuse of the identification number or other VAT fraud, not restricted on its face to fraud by that person, or indeed to some narrow interpretation of the word fraud. The concept used by the court is that the registration for VAT might result in the misuse of the identification number or other VAT fraud. In our submission, the analysis is driven by result, not by identification, not dependent on the registered person themselves being the VAT fraud. Paragraph 39, my learned friend likes.
Sorry, just to make sure I understand that a bit better. I think you're saying that the logic of the Kittle principle is that in the carousel fraud or missing trader fraud, it's almost happenstance where the evasion occurs.
I don't go quite that far.
Well, just trying to understand what you're saying.
So what we're saying about Kittle is, as the court said, if you knew, for example, that the transaction 6 steps removed was connected with the fraudulent evasion of VAT, you're treated in the same way as the person who evaded the VAT.
Well, but Cattell goes further. It says, or should have known, which is
Indeed.
very different.
Yes. But if you should have known, you're also treated as the fraudulent participant, because the protection for the taxpayer is the only reasonable explanation. Well, that's the test we apply here. So objectively, the only reasonable explanation is that the transaction is connected with fraud. You can't escape from it simply because you haven't asked the obvious questions. And once Cattell treats you as a participant on either basis, we submit that that is strong ground for the same applying deregistration.
Yes, so you say Cattell says, well, if you knew or should have known, your hands are dirty, you're tainted by the same fraud. And you say we should read Ablesio with that in mind, even though you have to accept that there are references in Ablesio that don't quite fit.
No, I accept that, and that's because, as I hope I've illustrated, the court's not really looking at, in Ablesio, what you should do in any given case. So one doesn't expect necessarily to find references to Cattell in there. It's a very broad statement of what you might do, and we submit that, in essence, Ablesio is best viewed as examples of when you might be able to do something, not as ruling out certain actions. And that's why I've sought to demonstrate that if this is an application of the general principle anti-fraud and abuse, you would expect the court in Ablesio to cut it down if it was saying you should only be applying this to fraudster qua fraudster. If one reads it starting from the point of the general principle, we submit that there's nothing in it limiting explicitly deregistration to those who are themselves fraudulently evading VAT.
Can we just look at the way the court rules?
Yes, of course.
This is the dispositive.
Yes.
And I take your point that the case wasn't sort of put as being about fraud, but it is answered rather specifically about sound evidence leading to the suspicion that the number assigned will be used fraudulently.
Yes. There's no getting away
And that
from,
is
from the black
indeed,
and white.
indeed.
It's what does the court really mean in that sentence? And our submission is will be used fraudulently. Doesn't say who by, doesn't say what the general effect is, doesn't seek to apply the background of serious and orchestrated VAT fraud that the court has grappled with in other cases.
But do you say, for example, that if you're involved in a carousel fraud, you're not actually the fraudster, would you still say that in fact your number is being used fraudulently because you're participating in that scheme?
If you knew or should have known, Cattell treats you that way, and therefore you
okay, that gets to the point.
So that gets you into the wording, if you need it, to link you from Cattell into this.
Okay, so you'd say the number is being used fraudulently because this person is participating in a carousel scheme, even though they are not themselves failing to account for VAT.
Yes, and with the rider that they had the relevant state of knowledge. It's not enough that they were just in the circle. They must have known or should have known. And then they're treated as participants. And that's one way of reading into the judgment, the result that we invite the court to adopt. The other is to look at the general principle that I've taken the court through and see, is there anything that rules this out? Is the court really here rowing back on the general abuse principle and saying, in this highly specific context of VAT registration, you must permit the registration of people who knowingly facilitate VAT fraud? We submit not.
Well, the court in Ablesio would have been well aware of Kittle by that stage, would it not?
but one hesitates to guess because it should have been well aware of the principle itself, should have been aware of other principles. But where there's no Advocate General's opinion, the court comes to it relatively cold. It's going far beyond the questions addressed to it. That's the danger of trying to read restrictions into general principles.
So is there any discussion of, is there even any reference to Cattell in
No,
the case?
there's a single reference to Halifax and the general principle that I've taken my lady to, which is referred to at 28.
There is some overlap in the judges, isn't there? Loomis and Cohen, if that's how I pronounce it.
I've not picked that up.
They're in both, aren't they?
So one would hope. But what one doesn't read here is the court saying explicitly this is not to be applied to anything other than someone who is fortunately evading VAT that's part of their obligation. So we submit that the answer really lies either in the general principle in it not being cut down, or in applying how people are treated in the VAT system for the purposes of the PVD, when once they know or should have known that the transaction is connected. My learned friend Mr. Carey points out that whilst there isn't a reference to Cattell, there is a reference to Metchek Gabona, if I pronounced it correctly, paragraph 32. Metchek Gabona being the extension of Kittel to zero rating transactions. That's as far as it goes. That seems to be in the context of the court repeating the notion that if the substantive conditions for the right to deduct arise, then that's what should be focused on. But we do submit that in the context of the general principle, if the court wanted to rule out some wider and ordinary application of the anti-fraud and anti-abuse principle, it would have been likely to say so. And we submit that in general the language does not get the appellant's case home. We do know that there are other authorities that have come to that conclusion. Plainly, they're not binding on this court, but they have independently come to the same view, and it might assist if I just provide you the references to those rather than taking you to them, if I might. So, volume 1 of the bundle, tab 25, page 128, paragraph 14. And page 138, paragraph 43, it's Thames Wines Limited. And then volume 1, tab 28, page 226, paragraph 48, in which Sir Ross Cranston adopted the approach of Cattell to the very registration. So from Ablesio, can I then move please on to the subsequent authorities? Proximor, not going to take you to it. There was no Attorney General, no Advocate General's opinion. Didn't concern any issue as to VAT fraud. And in our submission, the court said nothing further than had been said in Ablesio. Doesn't take matters any further. Can I then deal with City Land, please? On volume 2 of your authorities bundle, tab 38, beginning at page 487. Again, a case in which there's no Advocate General's opinion, and again, a case in which the court went further than the questions that were asked of it. The Bulgarian law set out at page 489, paragraphs 13 to 15, and its effect is summarised at paragraph 23 on page 490. The court there is dealing with legislation under which the mere finding of 3 formal infringements of the VAT rules, in particular the late submission of a VAT return, late payment of VAT or late issue of an invoice, is sufficient to exclude such a person from the VAT system, including for the most remarkable sums. On a brief understanding of the exchange rate, for example, the 0.46 Bulgarian levs in paragraph 20 is 20p. And the tax authority has relied on these very minor 3 strikes and you're out infringements to justify deregistration based on its domestic law. There's no suggestion of any VAT fraud at all, or any connection with VAT fraud at all. So it is perhaps of little surprise that the court found that legislation permitting this strict liability, 3 strikes and you're out result, including on the basis of 20p, was not permissible. And we do submit that the factual basis is far cry from that which is considering not an assumed facts but hypothetical facts as to how this may apply. The legislation was, as the CJEU later noted, designed as a penalty imposed on the person for repeated failure to comply with VAT obligations. The court then begins considering the questions at page 491, please. It says from 28 to 30 the same things that it's said in Ablesio and Popplewell. Notes then over the page at 34 that member states are required to take all legislative and administrative measures appropriate for ensuring collection of all the VAT due on their territory and for preventing fraud. Case. It's confirmation, if it was necessary, at paragraph 36 that Ablesio does apply to removing people from the register as opposed to just refusing registration. Then 37 we submitted as a hinge point in the decision where the court begins to consider national legislation providing for the removal of a taxable person which is designed as a penalty imposed on that taxable person for the repeated failure to comply with its VAT obligation. And in our submission, everything after that in the judgment is predicated on the existence of just such legislation. Hence the reference to principles applicable to tax penalties, not the earlier jurisprudence. So we know from Shern import, for example, paragraph 61, that the refusal of a benefit of a right stemming from the VAT system for involvement in fraud is not a penalty or a sanction. We submit that the CJEU here is looking at something different, which is not refusal of the benefit of a right in the case where you're involved in fraud, but rather where you failed to comply with your general VAT obligations and are then deregistered. But if it were otherwise, one would expect there to be an explanation of how what was said in Shern import is somehow wrong. So we submit there's nothing designed as a penalty in this case in any legislation. My lords, my lady have seen the letter which sets out the basis for deregistration, which is the right to it does not arise when the principal aim of the registration is to facilitate fraud on the VAT system. It's not a penalty for 3 instances of non-compliance.
So can I just clarify what I mean, in a way, it's not necessary to answer the preliminary issues, but I just want to understand what HMRC's overall case is. It's been some reference to the letter.
The
So I
overall-
think the principal aim is the way you express
Yes.
it.
So when one's looking at the prospective risk, it's that this taxpayer is principally registered for transactions where it knows or should have known the transactions are connected with fraud. So that's addressing the prospective risk to the VAT system.
And that's how you would answer proportionality.
Yeah.
Question.
Precisely. So that's why we, it's not assumed facts, but that's why we've referred to, for example, if it's proven 97% of the transactions were connected with fraud and the taxpayer knew, for example, that's still said to be disproportionate because there are some clean transactions. One would have to look at whether that's right. But we submit that the proportionality analysis is one on the facts. It's not it is never permissible. It's, you look at the risk.
The tribunals below didn't decide what the precise test was for proportionality.
No, the Upper Tribunal didn't determine proportionality. It preferred not to decide the correct approach to the test.
We haven't really heard argument on it, have we?
No, and I was going to address you on it unless I'm invited not to in terms of the test. But the test that the court's considering here on proportionality is the legal test as opposed to the factual
Well, indeed.
context
So
here.
I think it's probably not. As I said, I don't think it's part of the preliminary issues strictly.
Our submission is part of the preliminary issue proportionality. If this court is being asked to consider, as a matter of principle, it is never disproportionate to deregister person A in these circumstances. That engages the general question of proportionality. That engages the general approach. So whether it's the approach in Lumsden or a different approach. Our preferred approach is to say the question of proportionality for any given tribunal on such a case is to look at the facts and then determine, or as a matter of risk on the facts, is it proportionate to deregister or refuse registration to this trader? Because, for example, 97% of the transactions were connected with fraud, there was a finding of non. That's our preferred approach, but if we are to engage with the principle, then I will need to deal with that aspect. Might I finish Cityland first, my lady? So we do submit that the background to it is a penalty that's not in issue here. From paragraphs 39 to 46, we know the CJU says if removal is a penalty, it's particularly severe. But again, in our submission, the court can't really be speaking here about risk of fraud because it's already sanctioned refusal of registration in a blessing. So it must be addressing this 3 strikes and you're out more administrative issue. Paragraph 47, without such a full examination of the conduct, etc., it's impossible to ascertain exactly the nature of and the extent of any tax fraud committed by that taxable person. Consequently, to assess whether the removal constitutes an appropriate penalty. Well, firstly, the court doesn't confine what it said to any VAT fraud. It appears to be wider involvement. Secondly, the court doesn't say it's only tax fraud committed by the person deregistered that's sufficient. And we do submit that this is best viewed as the court giving an example of the type of consideration that can't be undertaken under the Bulgarian strict liability legislation. Thirdly, I iterate the point from Cattell and Sherd-Import that once you're within you or should have known you're deemed as a participant in any event. And again, this judgment doesn't address that or seek to rule it out. The ultimate assessment at paragraph 47 is to assess whether the removal constitutes an appropriate penalty. So that suggests in our submission, even if the legislation is so designed, not the case here, if on the facts it would be proportionate to combat VAT fraud to deregister someone, that can be done. And there's nothing in this judgment we submit that rules out deregistering those who aren't themselves VAT fraudsters but are treated as such by reference to Cattell. Insofar as it's said that this case is authority for the proposition that one can only deregister a fraudulent trader, we submit it's not. And even if it is, we submit it would be a radical and unexplained departure from the prior scope of the principle, done without the benefit even of an Advocate General's opinion. It's not binding on this court and it would be entitled not to follow it. One also in our submission sees clues as to what the court is actually looking at here. From paragraph 50 on the same page, the references to legal certainty. We know from what's referred to as settled jurisprudence, the Shern imports at 60, Cussons at 43, that once you are within the scope of the anti-fraud and anti-abuse principle, you can't invoke the principle of legal certainty to escape from it. So the court must be dealing with something different. Again, we submit that's a clue. It's dealing with penalties and the legal certainty of penalties, which is a different issue. And we do note that that issue does not make its way into the dispositif in any way. And the dispositif is, we submit, general. In terms of the actual ruling. What's required is for the tax authority to analyse the nature of the infringements committed and the conduct of the taxable person at issue. Well, that we submit takes matters no further than a blessio, and how in the proposed litigation HMRC would put forward a case of conduct of the taxable person in issue. So we do submit sitting down does not take matters further. So in terms of the appellant's criticisms of the Upper Tribunal, I've dealt with the 4 example steps of appropriateness and why that's not the correct approach already, because the principle applies equally to any right, benefit or advantage. One doesn't reason from specific instances what the scope of the principle is. And the appellant's criticisms of the decision in our submission and the focus on the text in Oblessio does not reflect, we submit, the consistent line of authority from the CJEU on the general principle. In relation to systematic undermining of the right to deduct in ground 1, it's not really trailed in ground 1, but one can deal with it now. It appears to have got to the point where my learned friends accept that if you fell within Cattell, you've lost the right to deduct on your original transactions, the ones that have already happened. If you didn't, you've got the right to deduct on those. So we're not looking at something in the past. We're looking at something in the future, as my Lord Justice Popplewell has already pointed out. If in the future you're going to engage in transactions in which you knew or should have known there was a connection with VAT fraud, you've lost the right to deduct anyway. So one can only be prospectively looking at untainted supplies in the future. In other words, the systematic undermining of the right to deduct argument is nothing more than an expression of the untainted supplies argument. Can't go any further. What the Upper Tribunal noted at paragraph 111 is that if you're deregistered, you'd be in exactly the same position as someone refused registration at the outset.
And this is UT
111, Judge. My lady. 111. And that's the situation that's envisaged in Oblessio. So in a blessio, the court we submit clearly sanctions refusing to admit someone into the VAT system at all. They don't get past the ticket booth. And then there is a focus thereafter from 38 of the blessio on the risk of misuse of VAT registration or other fraud. It's implicit in that focus on risk we submit that some legitimate transactions might also take place. You might buy your printer, your supplies, whatever they are. And so
is that an untainted supply or an untainted?
it's an untainted supply for the purposes of input tax if you strictly apply Kittel.
Yes, I thought that we were talking about for untainted supplies. I thought we were talking about untainted output supplies.
They're untainted input supplies, my lord. So once you're deregistered, you can't make the output supplies. So you can't charge the output tax. The concern raised by the appellant is to say, I'm deregistered, I can't deduct anything, and therefore, on my purchases, and therefore the right to deduct has been systematically undermined.
There's nothing to deduct from. I thought that was your simple point. If you have, you are not entitled to charge VAT on outward supplies, there's nothing to deduct from.
No.
For your input supplies.
No. So you can't
losing a right to deduct.
Yeah.
Deduction is not a concept which is engaged.
No. So that is a simple answer and an elegant one. The other answer is, in a blessio, by sanctioning not admitting
sorry,
someone.
just to be clear, deduction doesn't just mean deduction from output, it can generate a refund. So you're losing the benefit.
So you could have only zero rated supplies and then claim the deduction.
So you are losing a benefit.
One aspect of it is if you haven't charged any output tax, there'd be nothing to deduct from, but you would still have incurred your purchases. So
there are traders who routinely recover input tax.
yes, repayment traders who have no output tax. It's not a complete answer, but the complete answer we submit is, in a blessio, the court has sanctioned not admitting someone to the system at all. It must have been aware that that carried the risk of legitimate transaction. It's focused on risk. It's not saying as soon as you have one untainted transaction doesn't apply. So if a blessio operates in that way in relation to a fraudster, we submit there's no difficulty with applying it to someone with a Kittel state of knowledge. The CJU can't have refused complete admission to someone while saying don't systematically undermine the right to deduct if it was doing that very thing. We submit by referring to measures that systematically undermine the right to deduct, what the court's actually envisaging is things like the Bulgarian legislation. 3 strikes and you're out, administrative type penalties. No cognizance of conduct or culpability. That is systematic, and that tends to undermine the right to deduct. And we do submit that the word systematic in a blessio must mean something different than simply removing someone from the VAT system based on their conduct. And so we do submit that the Upper Tribunal was correct at 111 to decide that the CJU in a blessio was concluding that with the safeguards it had identified, deregistration or a refusal to register would not systematically undermine the right to deduct, or it wouldn't have sanctioned it. The alternative is that the appellant's correct in its conceded position that a single prospective untainted supply is enough. We submit that that simply creates a chance of fraud. We do submit that the better view is that considerations of the extent of the likely entry into clean transactions should take place as part of considering the factual case for deregistration. or refusal of registration in any given appeal, rather than it being determined that as a matter of principle, even a single clean supply automatically prevents deregistration. I move then on to ground 2, please, my lord, my lady. Much of the arguments on ground 2 are predicated on, we submit, the being correct on ground 1. If the appellant's correct on ground 1, it perhaps doesn't need ground 2. I've dealt with systematic undermining of the right to deduct. I won't repeat those submissions. Can I deal with legal certainty, please? I've taken the court to Shern, Import and Customs. You're caught by the principle, can't invoke the principle of legal certainty, and so it's unclear in our submission how the appellant can. But in any event, we submit the Upper Tribunal is correct to find 55 to 57 that there is no breach of legal certainty, and I've been through the ramifications in terms of the statutory provisions that say you can't charge output tax and the effect of deregistration being that you won't be able to recover input tax, but if you exceed the threshold, you're liable to notify HMRC in the ordinary way, who will then decide whether to register you. We submit that there's no breach of legal certainty. It's similar to Mobilex. Trader knows if I enter into transactions that I know or I should have known are connected with fraud, I'm not going to have my right to deduct. Trader also knows I can lose my VAT registration if that's reported. So we submit there's no uncertainty as to that. Indeed, the same considerations would apply to someone who is a fraudster who is then removed from the system, and there's no complaint by the appellant as to what their treatment might be. But as to fiscal neutrality then, as we've submitted at paragraph 32 of the skeleton, in this sense, fiscal neutrality operates in 2 ways. Firstly, neutralising by way of the deduction system the fiscal burden, so it doesn't apply to intermediate traders in the chain but falls on the final consumer. And secondly, requiring equal treatment. Again, based on Shern Import, it's unclear how the appellant can invoke that to try and escape the ambit of the abuse principle. But in any event, we submit from paragraph 33 of the skeleton that the Upper Tribunal was correct, paragraphs 115 to 117, to reject the fiscal neutrality argument. As the Upper Tribunal said, the CJU wouldn't have sanctioned the Blessio if it was itself a breach of fiscal neutrality. Further, in terms of fiscal neutrality in that strict sense of the deduction system, removing someone from that system in its entirety actually preserves the neutrality we submit. You can't charge output tax and you can't deduct it. That's entirely neutral. Nor viewed fiscally is there a competitive disadvantage in terms of the actual transactions. We set out the mathematics in the skeleton argument of paragraph 35. If you're not registered for that, you don't have to charge the output tax. You can't deduct the input tax. But if you are registered, you can charge the same sum, but 20% of it will be VAT, and you can get back your input. And we submit fiscally viewed. And again, it comes back, we submit actually to just another expression of the clean supplies argument, which is to say, of the clean supply argument.
Oh, the untainted supply.
So all roads we submit circle, or perhaps carousel, back to that. Back to that clean supplies argument. And then once you've disposed of the clean supplies argument, fiscal neutrality, legal certainty, we submit. That falls away. Again, all you'd have to do is claim prospectively you're going to enter into one clean transaction. Might I move to proportionality, please, my lord?
Yes.
As we've set out at paragraph 37 of the skeleton, the appellant's argument is that of necessity, a trader who has merely, and although we cavil with merely, facilitated fraud and who also tends to make clean supplies would necessarily, in any circumstances, breach the proportionality principle. Paragraph 40 of the skeleton, we submit that the Upper Tribunal was correct to decide. Paragraphs 110, 114, that in Ablesio the court concluded that the assessment of proportionality was to be made by the local court in the light of all the circumstances and evidence. In other words, as I've submitted, proportionality is a question of fact and degree. In any given case, it's not susceptible to the types of broad assertions made by the appellant that it can't be proportionate to deregister one category of taxpayer. Again, that argument has been rejected by lower courts. I can just provide the references, please. Tab, volume 1 of your authorities bundle, tab 25, page 123 at paragraph 6, page 128 at paragraph 14, page 138 paragraph 45. We submitted at paragraph 41. Skeleton taken to its logical conclusion, the appellant's argument amounts to saying again where there are a few untainted supplies, it's disproportionate to deregister. And again, we submit that has the tendency to produce a charter for fraudsters and those who facilitate their frauds. If one does need to deal with proportionality other than by reference to facts, we submit that the first issue to consider is what standard of review and intensity of review applies. And our submission is the correct test for proportionality where an EU measure is being implemented is one of manifest disproportionality, and we submit that the same approach applies to an EU principle. Can I invite court to go to Authorities Bundle 1, tab 27, page 161, please.
The Upper Tribunal just said whatever the test.
Yeah.
And so didn't engage with what was the appropriate test. Do we need to engage with what the appropriate test is, as my lady asked?
There appears to be an argument on the law that simply the measure itself is entirely disproportionate, i.e. you can never deregister someone in this fact pattern. And so in those circumstances, one is driven in my submission to dealing with the proportionality issue as a matter of law as opposed to the HMRC's preference, which is to deal with it on facts of any particular case. I'm loath to advance down that path if it's suggested that I don't need to, and where I've set out in the skeleton the reasons for our submission. But if it
well, put it another way, was the Upper Tribunal wrong to do what it did? Was it?
No, our submission is the Upper Tribunal approached it in completely the right way, my lady, of saying proportionality is an issue on the facts to be dealt with. That's what the court said in Ablesio, and that's why we're not going to determine who's right about the approach. So we do submit that the Upper Tribunal was right. This is a fallback, that if one does have to engage in the proportionality argument, we make submissions as to
okay.
the
So on your primary case, we could take the same, if you were right on your primary case, we could take the same approach.
yes, and we'd invite you to take that approach.
Yes, okay, that's another way of putting the point. You're not positively asking us to.
Not inviting
decide
you
this
to
debate.
rule on the correct approach to proportionality in law of necessity, because our submission is the Upper Tribunal was right. But if you are minded to not accede to those submissions and to engage in an analysis of proportionality, we simply sought to set out what we submit as the correct framework for so doing.
Okay, so on that basis, you refer us to Seabrook.
Yes. On that basis, my lady. The judgment of Lord Justice Henderson, with whom the Chancellor and Lord Justice Simon agreed. That concerned a judicial review of parts of the excise duty regime. One of the questions was the proportionality of a measure requiring a foreign owner of excise goods to have a duty representative if it wanted to hold them in the UK. Can we go to page 185, paragraph 69. His Lordship there begins to deal with the degree of intensity with which the principle is to be applied, considering what the Supreme Court decided in Lumsden. Go over, please, to page 191 and paragraph 84, please. My Lord Justice Henderson cites Lords Reed and Toulson on national measures implementing EU measures in Lumsden and the standard to be applied. Paragraph 85. About 6 lines down. Whereas the much less stringent test of manifest disproportionality usually applies when a member state is implementing an EU measure, such as a directive.
How does that help us? Because actually, in a way, I was about to say interpreting the directive, but we're not. We're interpreting a free, or trying to understand the scope of a freestanding concept of European law.
So our submission is, logically, one approaches it the same way as a directive. If there's a golden thread or principle running through a directive, which is itself a freestanding principle of EU law, what justifies a different approach to simply implementing a directive? If you implement the directive in domestic law, you're also implementing that general principle because it's inherent within the directive. So that's how we submit it does help. I accept, of course, it's not an identical read across because one's not looking at provision A as implemented in provision B.
Well, indeed, we're told this principle is inherent in community law generally, so it's not specific to the VAT directive.
No.
But you would say the same applies
Yes.
by analogy.
So the same applies by analogy and not least by what we come on to in terms of what Lord Justice Henderson goes on to consider. The point is picked up again at paragraph 92, that's page 195. Please. Dealing with the manifest disproportionality test. That stemming from MAF, Ministry of Agriculture, Fisheries and Food case. There was a domestic order made pursuant to EU legislation, and that's the test that's applied. And then in Seabrook itself, one goes over to page 199, please. Paragraph 105. The intensity of review instead was more exacting. And that is because the requirements were potentially discriminatory in their effect and restricted the freedoms of movement.
Sorry, you're reading from 105, did you say?
Yes, paragraph 105, my lady, page 199. So at first sight, the fact that it was implementing EU legislation pursuant to a broad discretion appeared to provide grounds for concluding that we were within Lumsden category 3, manifestly disproportionate. for the reasons that follow, this is the wrong conclusion. The appropriate standard is the more exacting one in the second Lumsden category of less restrictive alternative, and the reason that was adopted is because the requirements were discriminatory, primarily in relation to foreign owners.
I'd say for myself, I'm still struggling a bit with your analogy with implementing a directive. I mean, not least because that's a question of national, as I understand it, national legislation implementing a directive. And what's being said is you apply a manifestly disproportionate test.
Yes.
Here, you're trying to apply it, as I see it, to a rather different thing, which is effectively the discretion of the executive, or how the executive, the form of HMRC, applies a principle of EU law.
Well, there are two steps in our submission. The first is to consider how a blessio comes to operate within...
And sorry, just so I understand, we've been taken here to domestic authorities. But the whole point of this proportionality test is it must be part of the EU law test. It's not a question of how a domestic court interprets what's happened under domestic legislation. We're directly applying EU law principles.
You're directly applying them, but it's only through the domestic implementation of the VAT Act. So in the same way that Kittel doesn't have, or until recently, at least arguably anyway, there's no statutory basis in the VAT Act where you say, here's the Kittel principle. It has to be read through the Act as a kind of thread. And that's the point in Mobilex. So in the same way, we submit that you only get to having the abuse principle because the VAT system's enacted here through VAT. And so it is a species of putting an EU law principle into a domestic context. And that's why we submit that is the appropriate intensity review. It is not simply adopting some domestic measure.
I'm sorry, but what you're talking about is the remedy. In other words, what the HMRC's response is to what's happened. And it is simply that step has to be proportionate. There's no principle of law involved as to any test. It just has to be proportionate.
That's our preferred submission.
And I really don't, as Nadia said, I'm struggling with the idea that there is some intermediate step. And what are we reviewing? We're not reviewing domestic legislation. There's no reference in any of the EU authorities to, well, I mean, there is in respect of the Bulgarian legislation that is not a proper application of the principles involved, but that's different.
No, I fully accept that.
I just don't see how we get to, as a matter of law, the different test to decide whether or not the remedy that is actually imposed is or is not proportionate. It depends on the facts.
Well, it's because
the court doesn't take a different approach. You're saying the court, when it's looking at when nature, whatever that might be, has to decide is that manifestly unreasonable, or is there some other approach the court takes to deciding whether or not the remedy is appropriate?
My lord, can I frame it this way? As we understand it, the appellant sets out what it says are appropriate general measures within the law that are, for example, less restrictive alternatives, applying Lumsden. So the appellant says you look at that as the standard of review when comparing whether it's ever proportionate to deregister someone who had the Kittel state of knowledge. So that's how we arrive at the question. And if the question's to be posed, the answer has to begin, we submit, with what is the standard of review? And our preference, as I hope is clear, my lord, is that you don't need to go here. It's only if you do. And it's a choice between the Lumsden category of manifestly disproportionate or a truly less restrictive alternative. And our simple submission is that it's the less intense standard that applies here because one's looking at what is in effect an EU measure.
But what are you applying that to? This is what I'm struggling with. Is it HMRC's choice to?
No, we're not applying it.
What is it?
To try and pin it down, it's the appellant's argument that it is of necessity disproportionate when once you fall within the Cattell state of knowledge, be deregistered. So not any given set of facts, just as a matter of principle, it's not possible. It's always disproportionate. So that is the outcome that I'm trying to attach some legal framework to consider whether that's right.
Well, either that appears from the European authorities or it doesn't. If it doesn't, that's the end of it. If it does, then it does. I mean, it's not a matter of domestic law, it's a matter of what is the effect of the cases to which we've been taken and the legal framework generally.
And that is our primary position, my lords. I'm only addressing the fallback, which is if the court does need to address it. And if it does, we simply submit that it's the manifestly disproportionate standard that applies. But even if...
But just so I can make sure I understand your primary case. On primary case, if this matter went forward to a full trial, you would just be testing on the facts whether deregistration was actually proportionate. You wouldn't be looking at these tests, would you?
No, that's our primary position. You don't need to. But if an argument's made that of necessity a given principle being applied is disproportionate always, then that raises a different question. So make it plain again, my lords, my lady. We don't urge on you that analysis. We submit that the Upper Tribunal was right to say, Ablesio is saying you do this at a local court level by looking at all the facts. That's how you determine proportionality. The appellant says, no, that's wrong. As a matter of principle, it can never be proportionate to deregister someone with Cattell knowledge. That is a different question, and that is what I'm trying to pin a framework to determine how you'd go about determining. And any framework for a proportionality analysis, one has to address the intensity, and our submission is simply that it's the manifestly unreasonable as opposed to truly less restrictive alternative. But one might not even need to determine it because we set out paragraph.
But there's a domestic law alternatives.
Yes.
Entirely created by our domestic law.
They are.
What we're here concerned with is a test which is laid down in the European authorities on an overarching European law principle that applies irrespective of national implementing legislation,
Yes.
which is, as reflected, for example, in 34 Popplewell, it's got to be proportionate to the objective of preventing evasion. That's what it has to be proportionate to.
Yes.
It's a European law concept. Why has our domestic law got anything to tell us about it?
Well, we submit it doesn't. The appellant submits that because there are less restrictive alternatives, the court needs to look at them to see whether it's disproportionate to deregister at all.
Okay, but the distinction that Justice Henderson is discussing in Seabrook is a domestic law distinction about intensity of review, isn't it?
Yes, because there's different standards
Which is
depending on
the
what.
point I was making.
Yes.
My lord's made it much more succinctly than I have. In contrast here, we're trying to apply a substantive rule of EU law.
Yes, and I appreciate the difficulties, but one still has to end up with asking if the appellant's pursuing that argument, how do we determine what the standard of review is? Because it's clear that there are different standards.
Thank you.
And
Okay.
the court might say we don't need to because let's look at the appellant's best case.
Yep. Okay. Thanks.
So, firstly, we submitted if the CJEU saw no proportionate purpose in refusing VAT registration, it wouldn't have sanctioned it. Let's look at the alternatives. We've set those out at paragraph 48 of the skeleton, please. So this is applying the second Lumsden approach, less onerous methods.
Yes.
So number one, it said, well, denying input tax is more proportionate, and we simply submit.
I think we've got all that.
Yeah. So it might be that I can simply rest on my skeleton on those points,
Yes.
my lord and my lady, unless there's anything that strikes the court as to any further submissions on.
Thank you.
Right.
No.
So I'm sorry to have taken you on a slightly
No.
abstract roundabout of proportionality. Can I turn my back briefly?
Yes, of
please,
course.
my lord? Unless there's anything.
No, thank you very much. Yes, Mr. Moylan.
I was wondering whether a 5-minute break
Sure,
now.
yep,
I won't be very long.
no,
It would be
yep.
helpful to me.
Thank you.
Rise up there.
They were trying to tell me.
Oh, yeah, of course. What's usually being scrapped?
My brain can't cope with proportionality.
proportionate to the weather, is it?
It's not proportionate to the temperature. It's highly intrusive.
So it's 3 foot on 2 electrical fans. So yeah.
Both in the same background.
Yeah, it's quite worrying, isn't it?
Oh gosh.
So, again, guilty to between 6 and 7. No.
I feel like all the padding has
So if you
disappeared
drop
over
your
the
hand
course
away,
of the hearing.
There's also a cheap
Well,
fans for me.
none for you.
Worth noting the light
No,
streaming is just
It's not.
Where's Mark? Just in Chambers. Lemonade with him on the train.
It's good to see that.
I don't know.
He's in my
I
naughty
don't think so. She
Fine.
is actually showing us
interviewing
Oh.
that one. Naughty. I suppose I should have seen it more fully.
I'm hoping she's actually taken a break because she just
Yes. What's her best discipline?
Yeah, it has.
Yes.
Thank you for that indulgence. I'll be very quick. So far as my own friend's submissions in relation to, I'm going to call it etal moda rather than Schuldenport. As far as those are concerned, he laid some emphasis on what's in paragraph 64 about a situation where there's a taxable person who knew or should have known that was participating in a transaction connected with fraudulent evasion of VAT is considered to constitute fraudulent conduct on the part of that taxable person. And when Moylan went through his distillation by reference to a number of points of the propositions of law which he says emerge from the cases, he drew attention to the fact that in his submission a party who should have known in the Kitchen sense is someone who's to be regarded as fraudulent. But of course, as my lady, you've heard during the course of the discussions today, HMRC has not alleged fraud in any sense against Impact. Now, apart from that, the CJ Uniblessio doesn't, as we've seen, appear to refer to etal moda. So, in our respect,
Blessio doesn't refer to.
I call it etal moda or Schuldenport.
Oh, okay.
So it can't we say, he said when referring to fraud, it was intending to catch those who knew or should have known in the Kittle sense of a fraud committed by somebody else. And we say the better view is the court wasn't intending to catch them. And if it had been, one would have expected rather more in the way of consideration as to how that approach could be consistent with the court's own warnings about measures not systematically undermining the right to deduct. If the revenue's position based...
Order right.
Sorry.
Predate.
Yes, sorry. I think I'm getting things back to... I'm getting things back
the other way round.
I'm getting things back to front, forgive me.
Which I think is what you intend.
So
are you saying that Sherman Falk doesn't refer to the Kittle test? To a blessio?
A blessio doesn't refer to Ital Moda. Sorry,
No.
to Kittle, forgive me. I've crossed out Kittle by mistake. It doesn't refer to Kittle. And my Lord Justice Popplewell, I think, averted to the fact there was some overlap between the members of the court, but in any event. If it's HMRC's position, based on that analysis, where it's alleged that a taxable person knew or should have known, then that amounts to an allegation that the taxpayer has behaved fraudulently or should be taken to have behaved fraudulently. Then in our submission, HMRC should be required specifically to allege fraud on that basis so that the taxpayer has the protections in terms of pleading and disclosure and so forth referred to in Citibank.
I don't quite understand that. As I understand the argument, it is that Kittle, paragraph 56 particularly and following, treats someone who should have known as a participant in the fraud. That is, the factual allegation to support that is that your clients knew or should have known. The legal consequence of that, and whether that is or is not what is meant by a fraudster in a blessio, is just a matter of legal argument, isn't it? It's not a matter of pleading.
Well, my Lord, it seems as though the Revenue want it both ways, in the sense that they want to say that someone with, in the Kittle sense, who should have known, is to be treated as someone who's fraudulent, but without advancing a case of fraud. And that riding both horses in different directions like that, in our respectful submission, is not appropriate. The other point I was going to make by reference to Ital Moda was this. If one looks at paragraph 49 on page 411 of volume 2, tab 34, one sees the rights that are being referred to there.
Paragraph number again.
Forgive me, paragraph 49, bottom of 411. It is in principle the responsibility of the national authorities and courts to refuse the benefit of the rights laid down by the Sixth Directive when they're claimed fraudulently or abusively, irrespective of whether those rights are rights to a deduction, to an exemption, or to a VAT refund in respect of intra-community supplies, as it is in the case in the main proceedings. My point in relation to that paragraph, and one or two other paragraphs which I'll mention in a moment, is that all of those rights are rights in relation to specific transactions. The analysis in paragraph 50, where a taxable person knew or should have known that by the transaction concerned, it was participating in a transaction involving evasion of VAT. Paragraph 60 over on page 413 takes it one stage further forward. A taxable person who's created the conditions for obtaining a right only by participating in fraudulent transactions is clearly not justified in invoking the principles of protection of legitimate expectations or legal certainty in order to oppose the refusal to grant the right in question. All of that, we submit, relates to specific impeached transactions. And in terms of the limitations for which my learned friend argues on a taxable person's entitlement to rely on EU law principles of legal certainty or fiscal neutrality or legitimate expectations, we say that those limitations can't apply here, where one's talking about someone who isn't isn't, we say, attaining a right only by participating in fraudulent transactions, and where the deregistration will obviously have consequences in terms of that taxable person's trading generally, rather than being limited, as we saw in paragraph 50 and paragraph 49. The consequences are in relation to specific rights related to specific transactions which were claimed fraudulently or abusively. And I think the only other point I was going to make was this. There was some discussion of the fact that in Cityland there was no mention of fraud. We've seen what it was that Cityland was actually concerned with, the 3 or I think in fact 5 strikes of the route provisions. But it's striking, for example, in paragraph 47, page 493, that the court specifically focuses on the nature and the extent of any tax fraud by that taxable person.
Forgive me, can I have paragraph number?
Paragraph 47, page 493. They've gone to the length of referring specifically to the nature and extent of any tax fraud. And there's no discussion there of someone who should or should have known of a connection with fraud. My lords, my lady, those are all my submissions.
Thank you very much. Anything? No. Thank you all very much for your respective written and oral submissions. We will obviously be reserving our judgments. They will be provided to you in draft in the usual way for the usual limited purposes, as you will well know. And you will be given an opportunity through that process to provide or identify typographical errors. And we would hope that once you have received the draft judgments, you will be able to agree a draft order. If there's anything outstanding, we will deal with it on the papers. So thank you again, and thank you for dealing with it. So we finish at 3:30. Thank you.
What rise is there?